Hello and welcome to another video from me, James Wilson, from Park Square Barristers in Leeds. This is a short video for civil litigators who have trials coming up in the Manchester County Court. I'm grateful to my colleague in Chambers, Amrit Atwal, who has forwarded a copy of a redacted order that he received from the court in Manchester in relation to a trial that he's due to have in early May. If you have trials coming up between May and September, I anticipate you will get an order very much like this. I'm going to go through some of the main points in it. Excuse me for dotting around, I'm on multiple screens at the moment, but the headlines of the orders that you're likely to receive is this: that you can either consent to vacate the trial, you can consent to a remote hearing, or both sides can disagree about whether it should be remote or vacated. The next headline is that there's short timetables in this order. I'm going to post the order after the video. If you're on YouTube, it'll probably be easier for you to see the order if you go to my Instagram channel. But I'll see if I can get that up on the YouTube channel as well. But there is a short timetable for compliance, and so really I would, if I were you, I'd have a look at this order and see what you can do for the trials coming up and see if you can get ahead of the curve. If you agree that the trial is not suitable for a remote hearing, then you simply send in a consent order agreeing to vacate it and with agreed directions for the trial to be heard at some time after the 1st of October. Bear in mind that there will be tens, if not hundreds, of cases between now and October being vacated. And so you really want to think about whether yours actually is suitable, bearing in mind the guidance which I'm going to go through. If you agree that the trial is suitable, then you contact the court saying why it's suitable, those requirements for case summaries, contact information for the parties and counsel, and chosen video platform. Bear in mind that the courts are really running on Skype for Business. If you want to use Zoom, one of you will need to have a proper Zoom account, an upgraded Zoom account, so that you can run the hearing for longer than 40 minutes, and you'll have to take action to actively bring that case before the court via Zoom. If there's a disagreement between the parties, then there needs to be submissions setting out what the nature of the disagreement is. If it's agreed it will go ahead remotely, you need to say so. Now, all three of those agreements or disagreements, all three of those emails to the court saying what you want to do is still subject to judicial intervention. So even if you consent, it might be that a judge says that it's suitable for a remote hearing. I have to say, I think that's highly unlikely. So if you agree it's going ahead remotely, there's provisions within the order, and I'm just going to go to paragraph 8, which sets it out. The first and perhaps the most important thing is that the bundle needs to be a maximum of 250 pages, and there's a number of different orders looking at reducing the bundle size, but it needs to be in a single PDF. It needs to be accessible via an online data room like Mimecast. I've already done a video on preparation for remote hearing bundles, and I've done a video on how to create remote hearing bundles and how to bring them down onto your laptop and put them up onto Mimecast. There needs to be a reading list. That reading list needs to refer to only the necessary documents in the bundle. And in addition to that, the order effectively says, if you haven't put a document on the reading list, it's not necessary, so take it out. So the reading list is really a contents page. But I think what it's getting at is, and it says specifically, you can use extracts of documents if that's appropriate. Really, in personal injury case, for example, it's saying don't put in all the medical records. If you're only going to refer to 6 pages, then take out the 350 in addition. Have a think about whether your expert's qualifications are agreed. If they are, do you need the CV at the end? Do you need the first 2 or 3 pages at the beginning? Perhaps one page that says the expertise of this expert have been agreed between the parties, and then start at paragraph 5 for the where the expert actually deals with the case. The PDF, the 250-page maximum PDF, needs to be paginated from page 1, and that so the pages will include the skeleton arguments, the contents page, the case summary, etc. That's a logistical problem, and it will mean practically that you'll need to send the papers out to whichever advocate is doing the skeleton argument. You'll have to send the agreed bundle before it gets paginated. Now, it's the same order 3 to 7 days before the trial to file it. So the bundle will need to go out to your advocate to do the skeleton argument, to make sure that the skeleton argument goes in the paginated bundle and in itself is paginated. The whole tenor of the order is to make it easier for the court staff and the judge. There are specific subject headers which are required when emailing the court. So, for instance, when you send in the bundle for trial, the subject header needs to say bundle for trial. If you are disagreeing about whether it's remote or not, that header to that email is headed suitability submission. Those are in bold within the order, and as I say, they'll be appended to this. So it really is about trying to make this as simple for the court staff. And as I've mentioned in other videos, they are understaffed, and the organising remote hearings takes a disproportionate amount of time. At the last few paragraphs of this draft order, it's entitled Reasons, and that is something for you to consider in assessing whether your case is suitable. One thing it asks you to consider is, when assessing whether it's suitable, the delay that it will inevitably occur if it's not suitable. So the prejudice to your clients, prejudice to the evidence. So that's something to weigh in the balance when assessing whether it's suitable. Quite rightly outlines that remote hearings won't be suitable for all fast-track hearings. It specifically says those where there's a litigant in person, or there's a witness whose first language isn't English. They're unlikely to be suitable. Doesn't put a bar in it, but it does specifically say witnesses when there's 3 or more witnesses, or where there's allegations of fundamental dishonesty or fraud, that it will almost certainly not be suitable for a remote hearing. I'm going to do a video specifically dealing with FD and fraud later today, so if that's your area, then watch out for that. As I say, I'll put the order up with this video. If you have any comments or questions, please comment below or email me, and I'll see if I can help. Really, the headline is be proactive, get ahead of the game, check your diaries now for trials that are coming up in May, June and July. Look at the papers and see if it can be done in under 250 pages. See if you've got less than 3 witnesses, see if there's any FD, and if not, see if you can get it on